much, Carolina. Thank you very much for all you, the early birds that are sharing that very special moment in that Sunday morning. This paper that I presented to that conference is part of a major project centered in the investigation of how do justiciability of socioeconomic rights might contribute, if it really does, to the enforcement of that kind of transformational tool. The paper itself provides context about the Brazilian Constitution, how we are structured and how we deal with the matter of socioeconomic rights. It explains the interpretation of our immediate application clause, as Carolina have mentioned it in her own intervention. The Brazilian Constitution has an immediate application clause that was turned into immediate efficacy clause through constitutional interpretation. The paper also describes the legal framework about the right to housing and how the judicial claims are offered in Brazil, and it criticized the regressive effects that that style of adjudication is bringing in our reality. Thinking about the usefulness of that, sharing that experience in that specific forum, I remember that knowledge about the role of judicial enforcement of socioeconomic rights is being built through some sort of cross-fertilization. Therefore, I think that hearing about the Brazilian experience might be useful for you that are dealing with that same matter. And the Brazilian context, as you see, provides an interesting laboratory to that, thinking about judicial enforcement of socioeconomic rights due to its pretty particular normative and institutional framework. So let's start by contextualizing a little bit. The Brazilian Constitution was enacted in 1988. Through a transitional process, we have a military dictatorship ending, but it was a very negotiated process. Therefore, we have a national constituent assembly that was, while everybody was trying to build consensus in the most negotiated fashion, and as a part of impulsionating a transformative project, the progressive forces in the National Constituent Assembly opted for the strategy of including socioeconomic rights. Therefore, fundamental rights in general, socioeconomic rights specifically. We have in Article 578 fundamental rights, the first dimension of fundamental rights, those related with liberties, etc. And we have in the Article 6, which is dedicated to socioeconomic rights, something about 34 in the list. We have a lot of them sprinkled around the Constitution, and we also have a constitutional clause that provides that any kind of international treaty that mentions socioeconomic rights, fundamental rights in general, would be received in the same constitutional status that we have in our express clauses. We have the immediate application clause. It's also in Article 5. It do apply to all fundamental rights. And so liberty rights and socioeconomic rights are provided with the literal reference in the constitutional text is immediate application. But the very first concern when we have the enactment of our Constitution was to turn it into reality, to turn that transformational project into reality. So quickly, the interpretation given to that clause was that it should provide not only application, meaning not only some sort of public policy in the matter, but immediate efficacy. So there should be measurable effects and consequences of those constitutional provisions. The socioeconomic rights in particular that are mentioned in our Constitution as it's common in socioeconomic rights are referred in a very vague form. So indeterminacy is a very common feature. We have, completing the framework, we have also a constitutional clause that grants access to justice. And this means that you have legal representation provided by the state through public careers. You may not pay any kind of fee in order to grant access to justice, and we have a very decentralized judiciary. Therefore, even though Brazil is a very large country, it won't be that difficult, well, in certain parts of the country, surely, but mainly you will have easily access to judiciary, and you can propose whatever kind of claim you think it's needed. For you to have some kind of idea in numbers, translated in numbers, in September 2015, Brazil reached 100 million lawsuits. 100 million lawsuits on the go. We have a 205 population. That means one lawsuit for each 2 citizens. The official report of the National Council of Justice in 2014 reveals that we are spending with the judiciary branch something around $25.3 billion per year. $25.3 billion per year. This represents 1.2% of the GDP in Brazil and 2.3% of public expenditure, considering federal and state government level. So we have a massive judicialization scenery, and this is can also be credited to the fact that we have very deficient public services in all areas that you can think about. We have a bad educational service, bad public transportation services, bad health services, and consider that in Brazil there's a right to public health granted also in the Constitution. So this is the core problem. How to grant efficacy to indeterminate socioeconomic rights through adjudication or through massive adjudication. We also have class actions in Brazil as in India, as already mentioned by my colleague. But this is not the main tool that is used by anyone who goes to litigation, because there's a feeling that the judge won't be very willing to grant broader orders. So that kind of litigation in Brazil would happen mainly through individual lawsuits. Thinking about the framework to adjudication, judges face normally some sort of unwillingness, the legislative and executive branch, to develop the real content of those socioeconomic rights. They were brought to the Constitution in vague references. The development would certainly raise questions about financing, who are supposed to be the beneficiaries, and so the other branches are not very in the urge to decide about those things. So components as right owners, who are the right owners, eligibility criteria, any sort of prioritization, the content itself of the positive obligations that may come from the right. They are not designed in the Constitution, and usually they do not meet legislative development. The case study that is proposed in the paper is about the right to housing, and this is it's a pretty good example. The right to housing is mentioned in Article 6. It's already mentioned in Article 23, also mentioned, in Article 23, and no more reference in the Constitution. We don't have any kind of infra-constitutional legal framework for the right to housing. We only have a main public program that is held through the federal government and also with the aid of the local government. We just call it, in a literal translation, My House, My Life, Minha Casa, Minha Vida, which grant houses, concrete houses for people that get into a queue, etc., etc.